Welcome to the Student Symposium hosted by Temple's International Comparative Law Journal and Temple Law Review. My name is Kevin Feely and I'm a representative of Temple Law Review. Today I'll be your Master of Ceremonies. I asked my partner prior to coming in today that I told her I would be the MC for the evening, and I said, I've never really MC'd before. What should I say? And she replied, I've heard you speak. You should keep it pretty short. So, without further ado, I'm going to keep it pretty short tonight. Student Symposium is an opportunity for students from both journals to present their scholarship on important and pressing issues and be judged by our panel of experts. Our panel today is made up of Professor Ellie Margolis, Professor Shanda Sibley, and Professor Zamir Ben-Dan. And our presenters this evening will be Linnea Kelly, Kraus, Bria Renee Smith, Larkins, Maxwell's Wamser, and Hayley who will all be presenting on different topics. So without further ado, I'd like to introduce Linnea Kelly of Temple's International and Comparative Law Journal.
No, Laurie.
Hi, I'm Linnea Kelly, and I'm going to be talking about chosen name and pronoun policies in public institutions. These are policies that are meant to prevent discrimination, essentially ensuring that all faculty and staff at certain institutions address students by their preferred name and pronouns. And I will be talking about challenges to these policies under the First Amendment. For anyone who's known me for more than a minute, it's probably pretty clear that I will be arguing that these First Amendment challenges are meritless under existing law. So we're going to start with a really depressing part. With the social and political backgrounds that these challenges are arising against. So anti-LGBTQ plus legislation generally and anti-trans and gender nonconforming legislation specifically have been on the rise for the past few years. And when I say on the rise, I mean last year there were 174 anti-trans bills introduced in the US. This year it's already over 300. There's been an increase also in political rhetoric that goes with this, and that's been linked to increases in violence and in discrimination against the LGBTQ plus community broadly and trans individuals more specifically. And this kind of discrimination, like a lot of other kinds of discrimination, is linked to poor health outcomes. It's linked to increased rates of depression, anxiety, and suicidality, specifically in youth. But the good news is that affirmation and the ability to socially transition, including having others refer to someone by their chosen name and pronouns, is actually linked with a significant decrease in the negative health effects. So these challenges that we're talking about, the cases, I focused on 4 primary cases. There's Meriwether versus Hardtop, Loudoun County School District versus Kraus, and TICLJ versus Brownsburg Community School Corporation. Those 3 were educational contexts. One was university, one was an elementary school, and one was a high school. In both Meriwether and Kraus, the challenger was able to successfully argue that their First Amendment rights had been infringed upon by discipline due to failure to follow a name and pronoun policy. This argument was rejected in TICLJ, and a teacher who had been fired for repeatedly and willfully misgendering and dead naming students, that action was deemed appropriate. Taking offense versus state arose in a bit of a different context. This was in a healthcare context. There was a bill in California that was passed that was a broad anti-discrimination bill for LGBTQ plus elders in nursing home facilities, in long-term care. And this bill provided that staff was not allowed to willfully misgender or dead name patients, and that portion of the bill was struck down as unconstitutional. And so I'm going to discuss the legal background that this comes up under, and why all of these cases, the exception was wrong. First, we have public employee free speech generally. Public employees, while they are working, do not have the same free speech rights as any guy on the street who is talking about anything they want to talk about. Public employee free speech protections are analyzed under the Pickering-Connick balancing test. And that test is essentially balancing the interest of the employee to speak as a citizen on a matter of public concern against the interest of the state in promoting efficiency of public services, among other state interests. And when it is not political speech or speech on a matter of public concern, the deference typically runs to the government under this test. We also have recent guidance from a case called Garcetti. And in that case, the court held that the First Amendment only protects the on-the-job speech of public employees when the speech does not unduly interfere with any sort of legitimate government interests. And then further, in the area of public employee free speech, we have Title VII and Title IX, and these limit the speech of public employees to the extent that certain speech can be prohibited if it arises to the level of harassment or creates a hostile environment. And then it's a maxim that hate speech is protected in the US. However, there's limited protections on a lot of types of speech, and hate speech can be limited validly. Incitement to imminent unlawful conduct can be prohibited. So if you essentially if certain types of speech is spurring others on to unlawful conduct, that speech is not protected. There's also something called the secondary effects doctrine, which was actually developed in the realm of adult businesses and zoning regulations. And under that doctrine, certain types of expressive conduct or speech can be limited, time, place, and manner, not because of the content of the speech, but because of the effects that it's associated with. So if it's linked to particularly harmful effects, you can essentially curb that speech. Certain scholars have suggested that applying this doctrine to anti-discrimination laws would be valid and effective. Additionally, hate speech that targets individuals can give rise to liability and tort for various causes of action, like intentional infliction of emotional distress. Specifically, this isn't, if somebody's saying something in a public forum about a broader issue, this wouldn't apply. But if someone is talking about an individual, you cannot just sort of say whatever you want without any liability of it. These challenges that I examined typically involved religious objections to the name and pronoun policies. However, while I have heard it said that currently the free exercise clause is eating the establishment clause, as it stands currently, we'll see about within the next term, religious speech can be regulated in public institutions, and in some cases must be regulated because they may run afoul of the establishment clause. And likewise, religious speech, if it is targeted, persistent, and creates hostile environment, can amount to Title VII harassment. Under this framework, allowing these challenges to go forward is a dangerous expansion of First Amendment protections for a type of speech that has not before been considered protected. Under what we have now about public employee speech, the name and pronoun policies don't violate any recognized First Amendment rights. One of the primary reasons for this is that failure to follow these policies does impact the efficient operations of government institutions. It's actually, turns out it's bad for schools when everybody's filing Title IX complaints, which is what happened in Meriwether. And there's a problem here with the topic of public concern, and whether not only gender as a whole, but whether an individual's gender is a matter of public concern. I contend that it is not, that while speech expressing ideas about transgender rights more generally may be protected speech on a matter of public concern, the misgendering of an individual only expresses an opinion about that individual rather than about gender. And the other thing to point out is that these expanding protections may also jeopardize other anti-discrimination laws and policies that have long been recognized as valid. And I know this is a little bit outside the scope, but I wanted to end this with why this is so important. Definitely when I started this research, it was an issue that was worrying. And then I got to a point where I was like, oh, call us anything you want, just like stop taking healthcare away. And I'm actually like, okay, it's all part of the same thing. And acting on any of it matters. But right now there's 3 bills introduced in PA, 3 anti-trans bills, one that would target healthcare, one that would target participation in sports, and one that would restrict what people can be taught in schools about gender and sexuality, and more concerningly, would make it mandatory for teachers to report certain student disclosures to parents, which could endanger students. I'm urging everyone to contact representatives and tell them that this is not acceptable. I know it's easy in law to get lost in the minutia, but what we're talking about is, the most important government interest of all, the most compelling government interest, which is the protection of human life and dignity. Thank you.
Oh, I'm sorry. Sure.
All right. I'm not familiar with all these cases, but in Meriwether and in Loudoun County, it seems to me that the 2 primary arguments are about free exercise and academic freedom. Can you talk a little bit more about kind of what the counterpoints or the counter arguments would be, both the free exercise point and academic freedom point?
Absolutely. So to the free exercise point, the primary argument in favor of allowing these policies is that you don't have to grant an exception for free exercise if doing so would be unduly burdensome. As I say, as it stands now, we'll see once 303 Creative comes down soon. So if granting an exception for a religious exception would be unduly burdensome to the institution, it's not necessary. The other argument on that point is that to allow these religious exceptions may, at some point in a public institution, run afoul of the Establishment Clause. The other main point on that with academic freedom is a concept that typically is applied to university levels, which the Meriwether case was. The other cases were not, they were either elementary or high school. And academic freedom primarily relates to curricular speech. It hasn't been applied to sort of administrative speech or to the kind of speech that is just simply necessary to talk to people, like pronouns. So I would argue that academic freedom is when it's not an issue of the content of what's being taught in a course, it would not raise any First Amendment issues.
Okay. So I guess as I was sort of listening to you, looking at your paper, I was thinking, what about non-public institutions? Sort of, right? Obviously, Meriwether arose in the context of a public school and the elementary school cases are schools, but I'm just curious if you wrote your thought at all about how the First Amendment issues play out differently in the private institutions.
Yeah, there haven't been cases that I found addressing that yet, but I did find there are arguments that it could still, these policies could still be valid, provided that they're applied neutrally. I do think, unfortunately, in that situation, that when it's not a government imposed policy. It doesn't raise the same First Amendment speech issues, which is helpful in some ways and harmful in others. It does mean that in certain contexts, you can have schools who can and do require teachers to misgender their student. And that would be private institutions. But also, if you're introducing a policy that is, and you are not a public institution, then there are no valid free speech concerns about that policy because the government is not enforcing it.
I guess I'm gonna go a little bit off what Shanda's noted regarding academic freedom. Because the way that the courts define academic freedom is to apply to public school teachers, in addition to university, scholar, professors. So in terms of the response to the academic freedom argument, if that change, we're looking at an academic freedom paradigm that includes public school teachers.
I don't think it would change if we're looking at public school teachers. Sorry, I primarily saw it in the context of university professor academic freedom. I think actually academic freedom, from my understanding, is more limited for public school teachers, essentially because of the different sort of concerns and conflicts that the institution might have with the state. I think academic freedom primarily protects a university's speech as well. So you can argue that, and it has been argued that the university's speech is what's protected, not the individual professor. This is, again, contentious. That could be applied to schools as well. So if the school's speech is protected, then actually there's no problem with the school requiring you to address someone a certain way if it's not the individual teacher whose speech is at issue.
Can you foresee any particular downsides to setting precedent about kind of directing people about which words they can and cannot use?
Absolutely.
Speaking. Can you talk a little bit about what those might be?
So I think that there's always this tension between expanding and restricting individual rights so that they don't bump up against each other, and I think that's what we're encountering here. And in this context, one of the counter arguments that's been raised is like, well, if you can require everyone to address someone this way, then you can require everyone to address someone in a way that is maybe actively harmful. I don't think that argument has a lot of validity, primarily because you need an interest to justify that, regardless. And if your policy does not serve a legitimate governmental interest or does not promote the efficiency of the organization, then should be treated differently than a policy that is meant to serve legitimate either anti-discrimination purposes or simply just equity purposes within an institution. So I would hope that would be sort of a safeguard. I think that's sort of like it's often raised as like, well, if you require someone to call a student this name, then you can require someone to affirmatively discriminate against students in a certain way. And I don't view those as the same thing because they're not justified by the same types of interests.
Okay. Thank you.
Thank you.
Next presenter will be Linnea Kraus of the Temple International Comparative Law Journal.
Alrighty, welcome everyone. Thank you for coming. My name is Nate Kraus, and I wrote my article for TICLJ on the Belt and Road Initiative. Didn't start the slideshow, apologies. So this is a map of China's Belt and Road Initiative. As you can see, it's absolutely massive in scale. China's Belt and Road Initiative, generally speaking, and very briefly, is an infrastructure development project. It's basically connecting China to various host countries around the world, and it's focused on developing various forms of infrastructure. So my thesis is the BRI, the Belt and Road Initiative, threatens to wreak environmental havoc around the world. So how do we ensure that it's sustainable development, especially in Southeast Asia? That was the focus of my paper because Southeast Asia is incredibly important for the Belt and Road Initiative itself, and also it's just a biodiversity hotspot, an incredibly valuable region in terms of natural resources. So a little bit about the Belt and Road Initiative. It's cost over $1 trillion already. It was formally introduced in 2013, but some of these infrastructure investments began well before that. It's estimated it might cost up to $8 trillion by the time it's complete. Development's been involved in over 140 countries so far. Some forms of the infrastructure that's been developed are seaports, highways, railroads, pipelines, hydro dams. And one big problem along the Belt and Road Initiative is transboundary ecosystems. This picture here is the mighty Mekong River. It touches 6 different countries, including China, and then 5 others in Southeast Asia. And it's incredibly important to people's livelihoods. It's incredibly important in terms of biodiversity. So you can't have, say, 3 out of the 6 countries along the Mekong River cooperating and being sustainable. If one country has lax environmental policies, it could damage another country. This is a map of Southeast Asia. It also happens to cover all of the countries that are part of ASEAN, which is the Association of Southeast Asian Nations, which I argue is the best hope for protecting Southeast Asia and its environmental resources. Of course, the Belt and Road Initiative development. As I've mentioned, it's a biodiversity hotspot. It's incredibly rich in natural resources. It's the most valuable environmental region on the Belt and Road Initiative. And it's home to 15% of the world's rainforests, the Mekong River, which I just mentioned, South China Sea, incredibly valuable transboundary ecosystems. So there are worries about habitat loss, pollution, overfishing, species protection, livelihood protection, a lot of things need to be protected. So now I'm going to talk about a couple case studies involving problems that have occurred along the Belt and Road Initiative in terms of sustainable development. So the Batang Toru hydro plant in Indonesia, this is a plant that's under development. There have been allegations of forgery of documents. There's been law enforcement corruption. And recently, environmental lawyer Golfred Siregar, whose name is on the grave in the picture, was allegedly murdered for his attempts to protect the local rainforest and the endangered Tapanuli orangutan from development. He died in a mysterious motorcycle crash, but the New York Times alleged that he was murdered by local officials who wanted the project to go through. This is the orangutan I just mentioned was threatened. The dam is completed. It's thought that it will probably go extinct. These are 2 major railroad construction projects. One is in Malaysia, one is in Indonesia, and both involve extremely rushed agreements for construction. They're bilateral agreements between China and the 2 host countries. Involve poor financial planning and little to no environmental impact assessment, which could be a huge problem. I think this picture really captures the scale of the projects. The Lower Seasan 2 dam project in Cambodia, it's already had a negative impact on the fishing industry across countries downstream on the Mekong River system from Cambodia and from the dam, and it's displaced over 5,000 people. From this picture, you can see how intertwined people's livelihoods are with the Mekong River. These are floating homes, but you can see in this next picture, unfortunately, those without floating homes were displaced. And again, that's because of speedy agreements between developers and developees. Here's another dam. I'm including it because I think this picture is pretty impressive in scale. This one has actually been suspended for years, but it threatens local indigenous peoples. It threatens a rare species of river dolphin called the Irrawaddy dolphin. And ideally, when it was complete, it was supposed to provide 90% of its power to China. That's the dolphin that's threatened. And lastly, the Kaliwa Dam project in the Philippines. This one is a pretty crazy story, I think. An indigenous village elder refused to sign a free informed prior consent to cede land for development. He was allegedly forced to drink whiskey by local military and died that year. And you can see people are upset by that too. I'm gonna hurry it up because I'm running out of time. So these are the forms of law that are currently available for people who are victims of environmental harm under the Belt and Road Initiative. In my paper, I argue that international law is too aspirational, too soft, and unenforceable. Chinese law, you can see in this picture, this is the Chinese International Criminal Court, which is actually designed specifically to deal with Belt and Road Initiative disputes. And while it's promising, it's relatively unproven. It was established in 2018, and they're bound to consider Chinese governmental interests. So there are concerns that every decision they have is bootstrapped by that. And domestic law in host countries, it's too inconsistent, unreliable, corrupt, a lot of the time, self-interested, and there are enforcement issues locally. So the solution I propose is ASEAN, which is basically like the EU of Southeast Asia. It's an intergovernmental cooperation. The big problem with ASEAN is that when it was founded in the 60s, a lot of the countries were worried about colonialism. Every Southeast Asian country was touched by colonialism, aside from Thailand. So they were worried about state sovereignty, and they had this non-interference principle that they installed. But over time, they've softened that because of a need for to address shared transboundary environmental threats. So I argue that under ASEAN, we can install binding regional law, which I'll get to in a sec. Alternative dispute resolution mechanisms. Studies show that arbitration is more successful when it's localized, specialized. It doesn't come from a faraway forum. And also adjudicative bodies, again, for the same reasons, if they're specialized and localized, and ideally meant to address specifically environmental harm, they'll be more productive and more relied upon. So I'll briefly touch on this issue that I think shows a lot of promise for ASEAN. This is called transboundary haze. It's been a problem for years. Basically, once a year, wildfires from Indonesia create haze across multiple countries, not just Indonesia. I highlight the word transboundary. In 2015, more than 100,000 people died in Indonesia, Malaysia, and Singapore. It cost billions of dollars. They had to shut down schools. And it was so severe that it was cause for the only hard law provision under ASEAN, the ASEAN Agreement on Transboundary Haze Pollution, which was ratified by all ASEAN members in 2003. It's had varied success, but I think it shows a lot of promise. And there's another agreement in place that hasn't been ratified by all countries that I think would be a lot more successful. I think it shows the power that ASEAN could have in responding to environmental crisis and coming together to make sure that one loose cognitive system, in this case, the Indonesian government, doesn't wreak environmental havoc over the entire region. Thank you.
I have a question. So this was very interesting, and I will admit this is not something I know very much about, so my question maybe is either ignorance, but can you say a little bit more about the sort of enforcement mechanisms and law-making authority that ASEAN has currently, and is your proposal that those things need to be developed or that they're already in place and just need to be used in this way?
A bit of the latter. So in some sense, it does have a lot of enforcement mechanisms in place, ASEAN, but I think it's more of like a promising sign for the future. And again, the transboundary haze is a good example where they did actually get everyone to ratify the agreement in 2003, but it was not binding enough. And they have an agreement that they signed later, a lot of countries signed, but it hasn't been fully ratified by all ASEAN members, including Indonesia, which is the most important one, that I think would be a lot more effective. And I think, could be some sort of tipping point where a lot of these crises pop up and a country sort of, say Indonesia has to make a concession and police its, the fires that occurred, which, by the way, are from industrial forest clearing for things like palm oil operations. So maybe they have to make a concession there and spend some money and limit some development and potentially some capture earnings in the palm oil industry. But another country would then make concessions to, say, help with the fishing industry in Indonesia or something like that. So I think there's sort of a tipping point that hopefully we're on the precipice of.
This is also maybe a bit of a background question, but besides China, which countries are most directly economically benefiting from BRI?
That's a good question. I think a lot of that is to be determined. I didn't talk about it in my paper, but a huge issue under the Belt and Road Initiative is this sort of debt trap cycle. So I think it's most prevalent maybe in Sri Lanka, where China basically started developing an entire port in Sri Lanka, and Sri Lanka has run into huge issues with the debt they had to go into to fund the project. So, and then there's the question of, who benefits the most within these countries, the government officials who are helping facilitate the projects, and then the actual locals who, maybe their homes get flooded or things like that. So I don't really have an answer to that. But a lot of countries are involved, as you could see from the map I showed. So I think there's a lot of promise. And I spoke a lot about negative impacts of the Belt and Road Initiative, but it has a lot of potential to bring a lot of good things to countries in terms of commerce and actually green technology as well. So it remains to be seen how things will unfold.
Well, I guess I asked that question because from your first slide and the global map of countries benefiting, it looks like ASEAN is, for lack of a better way to state it, composed of some of the least economically developed countries in Southeast Asia, right? And so if you're looking for a political power or political entity to stand up to the power of China, then my question would be, it looks like Western Europe is going to get a lot of benefits, and it looks like countries like Chile are going to get right, and so kind of richer, more countries have a lot more political power on globals, right? And so I guess my question is, might it not be a better tactic to look to those countries to exert pressure on China in terms of the environmental costs?
Yeah, and that's a good point. And that's another thing I don't talk about as much in my article, but obviously the United States is a big player in terms of international development. So a lot of these countries can look to the US, but a big advantage, at least historically, to working with China is it's been a lot more sort of expedient, again, because China has much more of a hands-off approach. So I think that's a lot of the benefit they see in working with China. But yeah, it's a huge problem. Most of those 140 plus countries are lower middle income. And I think that's just another argument to, band together because you can have more bargaining power as a region as opposed to looking, to one world power or another. You can actually preserve your own interests as a region.
One concern I have is the potential for China and others to have outside influence from within ASEAN. And I'm not just talking economics, I'm also talking politics. The United States is a member of the United Nations. There's a lot of things that the United Nations doesn't necessarily support. So I guess, is there any way or what, if anything, exists in terms of ensuring that no one country dominates ASEAN?
Yeah. Well, China's not a part of it, so that would be a plus in terms of banding together as a region that's all dealing with China. But you're right that certain countries are, they're not all the same. Singapore is certainly very different from Vietnam. I think just again, it comes to this tipping point where you have various countries making different concessions as time goes on. And I think when you have these shared resources, or Singapore would be the South China Sea, everyone has a lot to lose in that sense. But you're right that military force is a concern. And, Myanmar is a bit unstable, to put it lightly. Military activity in the South China Sea is a whole nother topic. But I think you see a lot of countries around there looking to the US to sort of hopefully police China's activity there a little bit. So I think, unfortunately, in terms of the military back and forth, a lot of these countries will have to choose a superpower. I don't know if banding together will help as much with that, but maybe for preserving the environment.
Time for questions. Got it. Yes.
So our next presenter will be Bria Smith of the Temple Law Review.
Good afternoon, everyone. My name is Bria Renee Smith, and I'm the editor-in-chief of Temple Law Review's Volume 95. I am also a former special education teacher and administrator who has served in both brick and mortar and district and charter schools, and I'm happy to share my comment with you all today. So I'm pretty sure everyone here is familiar with how K-12 public education works generally. Students are grouped by grade level or level of performance. So there are AP and honors classes for gifted students, general education, college prep classes for what we call our general education students, and special classes as needed for students with disabilities. So for students with disabilities, we have to consider which one of these educational placements are the least restrictive environment. And my comment argues that for students with disabilities to attend cyber charter schools, key stakeholders must first decide on an individual basis whether such schools are appropriate educational placement options. That's not how it works currently. Currently, parents make that choice. So the issue at hand is that those groupings are considered in the same ways for both cyber charter schools and brick and mortar district and charter schools. But cyber charter schools, where students have some or all of their education administered through primarily electronic means, is not the same as face-to-face teacher-led instruction at a school building in a classroom with their peers. Federal protections for students with disabilities were non-existent until the 1970s. There was a feeling of an invisibility of the handicapped in America. So most students back then were institutionalized without education at all, and if they were given any education, they were not receiving the supports and services that they need. Actually, states had laws that excluded students with disabilities from their schools, and they stood. There were two early cases in the early 1970s, Park and Mills, that relied on the 14th Amendment to address the exclusion of students with disabilities. And then shortly after Park and Mills, the Education for All Handicapped Children Act was passed in 1975, and that act is now known today as the Individuals with Disabilities Education Act. That act aims that all children with disabilities have available to them a free and appropriate public education that emphasizes their special education needs and related services so that they can prepare themselves for future education. In IDEA, it has a least restrictive environment provision, and that provision states that to the maximum extent appropriate, children with disabilities, including children in public or private institutions or other care facilities, are educated with children who are not disabled, and special classes, separate schooling, and other removal of children with disabilities from the regular education environment only occurs when the nature and severity of the disability of a child is such that regular class you cannot use the regular class to satisfy the needs for that student. So I am arguing essentially that cyber charter schools actually constitute a removal from that regular education environment, because when they're sitting at home in front of the Zoom screen, they're not educated with any children, so they can't be with their non-disabled peers. So with that background, we're going to answer these questions fairly quickly because we don't have much time. What are cyber charter schools, and how are students with disabilities currently enrolled in cyber charter schools? So back in the 80s, school reform birthed the charter idea. So America was trailing behind other countries in innovation, and they thought that our nation's future was threatened by a rising tide of mediocrity. That's actually what they called it. And to secure our place in the world's economic marketplace, many different ideas arose of how to handle the problems that we have with public schools. And charter schools were created to give teachers more autonomy
in providing the services and supports they need for their students because they are actually in those communities and can help. The bargain there was autonomy or accountability. We're still waiting for that to happen because these schools are not performing any better than traditional public schools, especially not the cybers. So there are 180 instructional days in an academic school year. Brick and mortar charter school students show a gain of 24 instructional days in reading and similar growth in math compared to traditional brick and mortar public schools. However, traditional brick and mortar public school students, in comparison to cyber charter school students lose 106 instructional days in reading and 118 instructional days in math. That's a year. Remember, I said there's only 180 days in a year. So essentially sending your child to a cyber charter school is like not sending them to school at all. With that, traditional public schools are offered to everyone. Parents can choose to remove them and send them to either a brick and mortar charter school or a cyber charter school. Our state and federal tax dollars are allocated per student. So when they are taken from that traditional public school, that money follows them to the cyber charter school or the in-person charter school. So it's no surprise that cyber charter schools who do not have to pay to keep the lights on want the students that bring in the most money to increase their profit margins. So in my paper, I actually crafted an illustrative hypo to explain the situation more thoroughly. So Andre is a student with disability. These are all of his, and I don't take that off of that first one there, but these are all of his SDIs. So those are SDIs are specially designed instruction. These are all of the things that go into Andre's individualized education plan that his teachers need to provide to him on a daily basis. How can these things happen in a virtual environment behind a Zoom screen? How can you be in close proximity to your teacher and stay on task if you're at your house? How is positive reinforcement going to be administered for that child to stay engaged when they can essentially shut the computer when you start to get on their nerves? Frequent movement breaks. There's usually a frequent movement break. They don't go at all. They sit at home and don't do anything. But yes, as you can see, it's very difficult to meet all of these needs when the child is at home and the teacher is at a building that is not a school administering education. So COVID-19 shined a light on this issue. The US realized that remote learning is not an effective model for K-12 students. Even adult students struggled. I don't know about you all, but I was a 1L in 2020 behind a computer. I'm getting a lot of nods in the room, you can't see online. So the rationale for COVID-19 reopening is the exact same rationale for cyber charter school closure, in my opinion, but no, taking students out of cyber charter schools. Ironically, cyber charter school enrollment spiked during COVID because parents assumed that because they had been operating longer, they could know how to meet the needs of their children, and that's essentially not what happened. They're losing 100+ days of school a year. So my argument concludes with three things. So just like students with disabilities were excluded pre-IDEA, they're being excluded now with this high-tech option, and our most vulnerable parents are choosing to take our most vulnerable students and put them in this environment. Virtual instruction did not exist in 1975, so it's safe to assume that legislators did not intend for their regular education environment to be a Zoom screen, and the CDC declared virtual instruction due to COVID closures harmful for students with disabilities. So why haven't we taken a closer look at that when allowing parents to unilaterally place them in these failing schools? And I just wanted to give a special thanks to my faculty advisor, Professor DeJarnett, who is here with us today, to all the Temple RU editorial board and staff editors for helping me streamline all my ideas and thoughts, and to my former students and families who are the inspiration for this work. And now I'll open the doors for questions.
Always start.
That's fair. Okay. It's really easy to have a question. So there's one here. You didn't talk about it very much here, but I know one of the things you talk about in the paper that I'd love to hear you talk a little bit more about is your analysis of least restrictive environment and how that plays out in charter schools compared to.
Yes, so the least restrictive environment, it basically breaks down the percentages of where students are in the regular education environment. And I argue that like the cyber charter environment is like too unrestricted. It's like the least restrictive environment is supposed to say, don't put these students in a special class all day long. If they can handle going to lunch with their peers, if they can handle going to certain classes, if they have a deficit in reading, why are they in special education math? Because that was the issue pre-IDEA. If a student had some issue, they would say they need to be completely separated. With the cyber charter environment, I'm arguing that it's not restrictive enough. That child does not have the supports and services that they need in that environment. No one is there to provide them with the frequent checks for understanding those different things that they need to support them. And I break it down in my paper in like kind of like a 0, 50, 100% situation finding equation.
Yeah, it seems counterintuitive, right? The idea of cyber is not restricted.
Not restrictive at all. These children need additional services and we put them like completely on their own. Because the school day doesn't change in this cyber environment. Their parents are at work. They're really under no supervision at home.
This is not actually my question, but I do want to follow up on that. Prior to the presentation, it was my understanding that the least restrictive environment was about kind of a differential environment, right? And so these students can put in an environment other than a normal environment, it was unnecessary. But if all the students have no classroom contact, have no lunch, have no reading, right? If none of the students are getting that, then is it an impermissibly restricted environment to have students under IDEA getting that exact same thing?
That's the argument. That's why it's still a problem. People are essentially saying if we were to say students with disabilities cannot attend cyber charters, that would be the exclusion. But the problem is you're exposing all students to a poor option. Like all students shouldn't be allowed to go to schools where they're all like that data is not just for special education students losing 100 plus days. That's for all students that don't have disabilities, students that if I don't have somebody telling me that I'm sitting in the classroom right in front of me, I might, lay down while I'm taking my Zoom contracts class. No, I didn't do that. That's the issue. Like it's not restrictive enough for adolescents growing and needing instruction generally, and even more so for students who have added disability.
So that actually gets to my question, because what I think you're going to pull is that the IDEA can effectively kill cyber charter schools. And that's what you want completely, right? Yeah. And because there's actually kind of two ways to read this, right? Which is that cyber charter schools are apparently the worst options for schools. And really the major proposal is, well, we should make more effort to get the most students into the worst school, right? Or the other way to read it is, if cyber charter school cannot actually meet the needs of IDEA, and IDEA can kill the whole brand for all students.
Yeah.
It sounds to me like, even though you didn't say it explicitly, the second is your domain.
Yes. So when I was trying to craft this, I was trying to do it in a way that was narrow enough to meet that large aim, but fit within the confines of a large paper and also not just get so into loop, as I don't think cyber charter school should exist at all. But if we say like this is the starting point and we have to be held accountable to meet the needs of these students with disabilities, it will expose the fact that you can't meet the needs of any student.
I have a question regarding the origins. Also, like, because proposing the solution, of course, is do you think that the origin of the cyber charter school movement genuine? That any current option?
Yes, I think the origin is genuine. So cyber charter schools were created as an alternative to homeschool, where the parents were initially the facilitators. I'm not saying that this can't work for all students. If we have a hearing impaired student who that's their only disability and they need closed captioning, why not? Why couldn't they attend school online? But that's not every student's case. And it doesn't take into consideration the fact that they're targeting people that the ads say, are you tired of your child being bullied at school? Are you tired of the gun violence in Philadelphia? Take them out, sit them at home. They're not advertising to people who would have home facilitators, somebody who's going to be there doing the things that the teacher can't do at home. Like, I think this will be a great option for a child that's pursuing sports vigorously or active. They can't be in a classroom, but it's not for students who need additional support.
We're technically out of time, but we can talk one more.
All right, so the other big question I had that ask is that, so I understand this idea and why you chose to do it this way. But I can see sort of going after it through an idea, going after some arbitrary through an idea lens could cause many people to file equal protection claims. And I know you addressed that a little bit, but can you say a little bit more about why you don't think that's an obstacle to this approach?
I think it might be an obstacle to this approach. However, I think that we're looking at, I'm asking for it to be made an educational placement option, like as like homebound facility, like juvenile facilities, all of those things are other options. We have to consider why a student would need to be in that situation. If we had to put that, rather than it being a school choice, if we had to put that as a checkbox on an IEP, it would get people to have that conversation a little more. I don't think that general education students should be able to be unilaterally placed. And another portion of my argument is that we need to have some accountability for those schools and the outcomes that they produce. So if we're seeing that they're not producing outcomes for those general education students, those general education students are coming to traditional public schools and traditional charter schools and having to have child bond obligations and getting found needed for special education services, I think that will address the issue as well. I went at it through this approach because I have a special education background, but I do know that there would be equal protection claims saying why the general education student would not need this extra layer. Yeah. Thank you all so much.
Our next presenter will be JJ Larkins of the Temple International Law.
Hi, everyone. My name is JJ Larkins, and in the next 8 minutes, maybe 8 minutes, we'll see. We're going to do 3 different countries' domestic criminal laws. We're going to do some human rights laws. It's going to be really fun. But I'm going to talk specifically about lessons from Canada and Australia for implementing government-sanctioned overdose prevention sites here in the United States. So I want to first start this presentation with a story close to home here in Philadelphia, and that's of Safe House. So Safe House is a nonprofit that was tapped in 2019 with opening the first overdose prevention site in the United States that was sanctioned by a government. So to do this, after they got government approval from the city, they got lots of local buy-in. There were originally plans to open the Safe House overdose prevention site in Kensington, then in South Philly, but what happened is U.S. Attorney William McSwain had filed suit against Safe House in the Eastern District of Pennsylvania. He claimed that it violated the federal statute, and in 2020, in the district court, Safe House actually won. Judge McHugh held for Safe House and said that it didn't violate the statute, but there was a hold given because of the COVID-19 pandemic. So with the public health concerns, the judge was concerned that people coming into and out of the site in the middle of the COVID pandemic was dangerous. Then that gave time for an appeal. 2021 it was appealed to the Third Circuit, and it was reversed 2-1 to the Third Circuit. So the Third Circuit found that the Safe House was going to violate the crack house statute, which you can see here. That statute prohibits maintaining any place for the purpose of using any controlled substance. So the Third Circuit interpreted this purpose as Safe House only needed to knowingly and intentionally open its space for visitors to come to the site to have the purpose of using any controlled substance. However, Safe House argued our purpose is to save lives and to reverse opioid overdoses, but the Third Circuit did not buy that argument. Just to kind of get everyone up to speed now on what happened after Safe House. Also, as I'm writing this comment, things are changing every few months too. So it's kind of an exciting, topic to continue to work on. The Supreme Court denied cert in 2021. Interestingly, the Solicitor General had actually declined to comment on whether it should get cert or not. And that tracks still today. The Biden administration has not said one way or the other about whether it would support overdose prevention sites in the United States. And currently, Safe House is on remand before the district court in Pennsylvania. There have been negotiations going on with the Department of Justice and between Department of Justice and Safe House about what might happen on remand. There's this whole RIPRA argument that I don't get too far into in my paper. It's focused a lot on Canada and Australia, but I can talk about that later if you want. But now to get really to the crux of things, I wanted to kind of outline where we're at in the United States before turning to Canada and Australia. And what I'm arguing is that given this complex legal landscape in the United States, And given this weird standstill of negotiations between the State House and the DOJ, advocates and policymakers really need to look internationally at Canada and Australia, two countries with federal constitutional systems that are similar to that of the United States, and also two countries that have already sanctioned overdose prevention sites within their borders. So we'll talk about Canada first. So first I'll talk a little bit about how they were legalized in Canada. So in 2003, the Health Minister of Canada granted Insight a federal exemption under Section 56 of the Control of Drug and Substances Act to operate a 3-year pilot study for an overdose prevention in Vancouver. So that means that was Insight was the first government-sanctioned OPS in North America in 2003. But that exemption expired in 2008 when there was a new conservative government that failed to renew it. That led to PHS, which was the organization that was operating Insight, bringing suit in British Columbia. It got appealed twice, and then there's this very important court case that came out of the Supreme Court in Canada that held unanimously for PHS. And it said that the minister's refusal to renew that exemption in 2008 violated Section 7 of Canada's Charter of Rights and Freedoms, you can see here. So essentially they said that because the minister didn't renew or approve this exemption within the criminal code of Canada, it violated principles of fundamental justice, which you can see the last phrase here of that phrase in the charter. So moving on, because now that was like, I thought I kind of throughout my comment really looked at this case and looked at the State House litigation and really two different coins, really, like completely opposite the way that it went. And in 2009, one of the remedies that the Supreme Court of Canada ordered was that the federal government had to amend its guidance on how overdose prevention sites would be implemented in Canada. And classically, there were 26 conditions that had to be met before any overdose prevention site was approved. These were actually more restrictive than what Insight required to start off with. But in 2015, the Trudeau government replaced them with 8 conditions, and that's the current legal standing of overdose prevention sites in Canada. They have to apply for an exemption under Canada's criminal code under Section 56, meet these 8 conditions, and then they can be approved. The only nuance I'll talk about is that in 2020, amidst COVID-19, Health Canada permitted these temporary, like urgent need sites that operate similarly to overdose prevention sites. They don't have to go through this 8-condition process. So you have this weird, like 2-lane dichotomy where there's these temporary sites, there's these permanent sites. They're doing pretty much the same thing, but they have 2 very different approval mechanisms at this point. And so if you're operating a temporary site, there's not much federal oversight there, as opposed to the permanent site, there's tons of federal oversight, and it takes years and years and years to get approved. Australia, last country we're doing this. Before even Canada, in 1999, the New South Wales government was the first one to legalize overdose prevention sites. The most important thing to remember about Australia is that Australia doesn't actually have any federal criminal statutes around drug possession and drug use. That all is left to the states. So in New South Wales, they amended their state criminal codes to carve out exemptions specifically for overdose prevention sites. That they finally approved this trial of Uniting MSIC, that's the name of the actual site that was opened, and then it was like approved as a pilot, then it was approved on an ongoing basis, and then 2018 in Victoria, that became the second state in Australia to then legalize and amend its criminal code as well. But New South Wales and Victoria are the only 2 states in Australia that have done this in their criminal codes, which means that all the other states in Australia it's currently outlawed. So that kind of gets me to the focus of my argument. Now that I've really very quickly, I'm sure there's like lots of statutes that were thrown out at you, gone through how this happened in Canada and Australia, and I've kind of inspired my paper by looking at lessons on federal action and lessons on state and local action. So I kind of see 2 main possibilities and 2 lessons on federal action. One is that to implement these OPSs in the United States, Congress could carve out an exemption similar to what happened in Canada when the minister ordered an exemption to actually happen for Insight, and Australia for state criminal codes to allow overdose prevention sites. That exemption could be within their pack house statute itself. Of course, the Biden administration could always clarify its guidance on how they should be implemented to kind of avoid these violations of federal law. So I think that kind of going similar to the Cole memorandum and how marijuana legalization has proceeded in the United States, where essentially the state legalizes marijuana for recreational use. The Department of Justice said in the full memorandum that they wouldn't prosecute anyone for possessing or using in that state, or so they say. I also think a big lesson that I learned was it's important to avoid a lot of bureaucratic obstacles that this is going to happen in the United States. So in Canada, this having to affirmatively apply for exemptions, these are really long, they take years. They have to present all these crime studies and community consultations, and it just takes a really long time. And the opioid overdose crisis just continues to worsen. So that really is valuable time here. Finally, I think it's important to make sure that state and local action isn't too flexible, I would say, in this area. So for example, in Alberta, you can see at the bottom there, but in Alberta, there was a law that was passed last year that requires the ID to be presented at the overdose prevention sites within Alberta. And that was upheld constitutionally a couple months ago. So those types of laws policymakers should also look out for in the US. Finally, with state and local action, despite the federal crackdown statute, we've already seen some state and local action in the US. We can talk about this more in the questions too, but New York City just last year approved two government sanctioned overdose prevention sites. Rhode Island passed a law legalizing a pilot study, but no actual sites opened in Rhode Island because there is a local approval provision in there, and no cities in Rhode Island have taken it upon themselves to approve one. Of course, there could be preemption challenges here with the crackdown statute. Again, I talked about that a little bit more in my paper. It's important to notice that, even though the federal crackdown statute in the state bus litigation was the main legal barrier in the US, we still have all these state codes that talk about drug use and drug possession. And carving out exemptions in those is equally as important. And just finding a balance between federal and state local action, I think, is important. Like, for example, in Australia, we have two states that did legalize this, but then we have opioid overdose rates in all these other states in Australia that are even higher than that in New South Wales and in Victoria. And so they're not getting the benefits necessarily because it's proceeded state by state in Australia. One note on civil disobedience and advocacy before I turn it over to questions is that governments in Canada and Australia really only legalized these overdose prevention sites after significant protests. Illegal operation underground. Insight was opened as a surprise, and then it was kind of like we opened it, what are you going to do? So I think US policymakers really need to listen to activists and to inject and drug users and people who are using these sites when kind of refining their approaches for how best to implement these across the United States. This presentation.
I guess I'll start. One of the, I think, most pervasive cultures in America is top on crime culture that has driven the country in the last 5+ decades. And so I'm curious to know your research into any such culture like that existed in Canada or in Australia. And how do you think that academic policymakers are proposing this to get past that culture in America?
Sure. So to answer the first part of your question in terms of whether that culture existed in Canada and Australia, that was less of something that when I was doing my research that came up consistently throughout the articles that I was reading. It doesn't say that it wasn't necessarily there, but I know so much research, so much I've read about and learned about in the United States in particular was the war on drugs and certainly racial aspects of the war on drugs, mixed in whatever, I'm not going to go into all that. But to answer your second question about how are activists necessarily in the United States going to grapple with that? I think how I may answer that is I think there's an interesting moment right now, which kind of inspired me to write this comment in the first place, because we're in the Biden administration right now. And I didn't talk about this in the presentation, but I talked about it in length in my comment, is how President Biden himself has a really unique role in this because he was the original sponsor of the federal crackdown statute when he was a senator in Delaware. And he was a proponent back in late 90s, early 2000s of these hard on crime policies that were going after houses and raves and whatever. And what I'm kind of arguing now is that maybe this is less prevalent or was less prevalent in Canada and Australia, but like this is the moment now to kind of remedy some of those wrongs from 20, 25 years ago, like you said, 5 decades ago.
I guess I want to raise the NIMBY argument and kind of have you address that.
Sure.
So when we're talking about the Australia example and state by state solution or determination, I think we have to recognize that the geography plays a big role in that, right? Australian states are humongous, right? United States are not, and so let's say that Jersey decides, based on your proposal, right? We go to state by state, and Jersey says we're in, and Pennsylvania says we're out. Yeah. Right. What will naturally happen theoretically is that a lot of people who want access to this resource will then cross state lines, right? And theoretically, that could make a less pleasant environment in some ways for people who live in Jersey, or so they might say, right? So how would you address that kind of argument about how kind of the state by state solution would actually impact kind of interstate travel for access to these resources?
Sure. So in terms of impacting interstate travel for these resources, I think Australia is helpful and not helpful in a couple of ways. So in terms of how it's helpful, I think what it shows is that there's always been a need for these sites in tons of different types of communities. So I think typically what we've seen here, living in an urban place like Philadelphia, in New South Wales and in Victoria, these were all open in like urban spaces, for example. But in terms of like where these needs are, like overdoses happen in rural communities, they happen in suburban communities, they happen in urban communities. So I think what I would say in terms of the travel argument in Australia is that because it's not helpful because, like you said, I guess in terms of geographic scope, it's hard to travel between these states in Australia. So that doesn't make it as helpful. But in terms of just like directly responding to the NIMBY argument itself, I would say, people one could approve, let's say we're going back to the New Jersey hypothetical. If New Jersey decides to approve them and Pennsylvania doesn't, people are going from Pennsylvania to New Jersey. I don't see why, if New Jersey residents are the ones that voted for people who were the ones who decided to implement this site in New Jersey, that they would then turn around and have an issue with people coming from Pennsylvania to New Jersey to make created a worse, and I'm sure they probably would, to be honest. But they Pennsylvania, New Jersey, drug use out of it. But I think I guess I don't know. It's something I didn't think too much about in my comment, I guess, in terms of interstate travel. So something I could definitely focus on. Again, seeing it's kind of like up in the air now about what's going to happen. Like so much is up in the air about what's going to happen in terms of is something going to happen federally? Is a state going to do it? Rhode Island kind of did it. New York's kind of doing it right now. New York City, I mean. So I think it really is just going to depend on where we go from now.
I just asked this because this was actually one of the arguments about the state injection side of Kensington, right? It was that some people were saying that Kensington is already the open air drug market, already attract people from out of state into that environment, right? And then doing this would only increase the attractiveness of that location for people who are not Pennsylvania residents. And I think that some state by state solutions require some level of extended political will, right? That I can foresee someone saying, I'm for it if it's for Philadelphians, but I'm not for it if it's for 700,000 people coming in to access this resource here in my environment.
Right, and I think that's why, one of my main critiques of that state by state approach is the fact that it's not becoming a resource for people in states that don't have it necessarily, but I guess also then that it really concentrates the services to particular areas. And what I would respond also to that is all the evidence out there that crime doesn't increase. There's less drug paraphernalia on the streets around there. We're kind of buying into some arguments here in the media about we're attracting drug users and they're going to make it a less desirable place to live, a less far place to go. And evidence just doesn't show that either.
So I guess sort of listening to you and thinking about that and these questions, it struck me as in your presentation that you drew lessons from both Canada and Australia, but they're quite different from each other. And so I guess I'm wondering, like if you developed sort of an independent sense of like leaving aside all of the constraints, which are many different levels to actually do this, what you see as the best model.
Yeah, I think what the best model is what's kind of similar to happen in Canada, but what I would argue about the big things that I learned in Canada were really, if we're gonna have some sort of giant, Congress is gonna pass something, we're gonna have some big Supreme Court precedent that applies federally, so there's some big government action that just happens across the country, that there needs to be a balance between regulation and have the ease of access to actually opening them in communities and getting the services directly to people. So the way it works right now, it's years and years to get an approval for one in Canada. There are restrictions about how you have to apply every year. And so I think toning that down and working with people who are actually using them and operating these and what works for them, because then you're applying every year, then you have to devote a certain amount of money to grant writers that are also going to be applying for these every year and things like that. So some less onerous process than what currently happens in Canada is what I kind of came to with what would be most desirable of the United States. The magical world where none of those legal restrictions existed.
I have time for questions. Thank you so much.
My next presenter will be Maxwell Wamser for.
Hello, my name is Max Wamser, and I'll be talking about the U.S. Supreme Court case Brnovich v. Democratic National Committee. And I'll specifically be looking at it in terms of considering how Justice Alito's majority opinion and Justice Kagan's dissenting opinion reflect different understandings and theories of democracy, what those interpretations using these different understandings of democracy mean for interpreting Section 2 of the Voting Rights Act and any election legislation in general, and what that means for voting rights. My thesis is essentially that Justice Alito, his opinion and interpretation of Section 2 represents an understanding of democracy that is contrary to the one intended by the original drafters of the Voting Rights Act and the drafters of the amendment to Section 2. But still, the text of Section 2 is discretionary to the extent that it permits Justice Alito's interpretation, despite the fact that there's a different understanding of democracy. So to talk a bit about the case, it was a challenge, as it said, under Section 2 of the Voting Rights Act to two Arizona election laws. The first one outlawed essentially the possession of mail-in ballots by third parties other than voters' family or post office worker. And this specifically was targeting these third-party ballot collection agencies, companies. The other one was a law that specifically said that provisional ballots cast outside of a voter's designated precinct should not be counted in voting. And the DNC was saying that these were in violation of Section 2. What Section 2 essentially says in this context is that laws cannot limit the access or opportunity of voters to the polls on the basis of race. And the DNC was saying that these laws did so for Black, Native American, and Hispanic voters in Arizona, specifically because these groups were more likely to utilize these third-party ballot collecting agencies, and also more likely to cast provisional ballots outside of their designated precinct. So Justice Alito, writing for the majority, he upheld the Arizona election laws, and Section 2, just to describe it a little bit and how it functions, it is an effects test. So it looks at what are the effects of the legislation and how they impact it. It doesn't require discriminatory intent, as our 14th Amendment protection claim might. And it just looks at, is there a disparate impact among the different voters on the basis of their race? So it just looks at the effects. The test itself is a totality of the circumstances test, which applies a wide-ranging number of factors called the Gingell's factors. And they range from pretty wide range of stuff. It's fairly open. And the purpose of it is it's supposed to be very fact intensive and to look specifically at the social context of the state and then its different localities, and so you can look at the facts and kind of understand how everything's going on there. So to go to Justice Alito's opinion, as I said, he upheld the Arizona election laws. I won't go through all of the factors that he applied because there's a wide number of them, but I think they can fit generally within two different buckets. And I would say those are practical governance and state interest. In terms of practical governance, he kind of relies on this idea of the typical burdens of voting, which is a quote from a Justice Stephen Plurality opinion in the case Crawford, and that was specifically about voter ID. And the idea there is that there are certain, in the practice of running elections, there are certain barriers that will happen to voters to access polls that are an inevitable part of elections and how they function. And he says that sometimes, those are inevitable, and we can't go beyond trying to limit those. And he said that to some extent, it's on the voters to overcome those barriers themselves. The other one, as I said, is state interest, and the focus there is on voter fraud and the idea that states should have an interest in how they run their elections and what types of things they want to control or limit in some ways. So he, looking at those, I think, two general categories, says that those sort of outweigh what he viewed as a lesser disparate impact based on these racial groups. So I argue that interpretation and that the underlying understanding of democracy that's within that interpretation could be called a pragmatic theory of democracy and essentially focus on exactly those things that I was discussing about practical governance and the structure of government, in this case, federal-state balance when it comes to running elections. Contrasted with Justice Alito's pragmatic theory of democracy would be Justice Kagan's opinion in dissent, where she applies what I would call a normative theory of democracy, one that looks at the underlying values of democracy, one that looks at the principles and the morals that drive democracy. So things like collective decision-making, things like furthering the collective will to the greatest extent you can. My basic argument is that while I agree with Justice Kagan that the normative theory of democracy was the intent and the understanding of both the 1964 Congress and the 1982 Congress, which amended Section 2, I think that Section 2's text as itself and its totality of the circumstances test gives a very wide range of discretion to judges. These very discretionary factors, it's a non-exhaustive list. And that per this text of Section 2, especially to a textualist like Justice Alito, his understanding of democracy is permissible in how he views it and how he applies it to the Arizona election laws. So my recommendation, my policy recommendation, I support voting rights. I think that there is validity to Justice Kagan's argument about the importance of them, especially in present contexts, and the needs for voting rights in current elections. And I think that I argue that Congress, if it's passing future voting rights legislation, it should try to embed a normative theory of democracy within this legislation so that it can sort of stay in the hands of judges like Justice Alito, like the more textualist current majority of the U.S. Supreme Court. And I think there are a number of ways that it can do that. I discussed a few in my article, including the idea of codifying this thing called the democracy canon, which is an idea by Richard Hosden, which is that when interpreting electoral legislation, judges, and where judges find an ambiguity, they should interpret it sort of in the favor of broadening access to polls, broadening opportunities for polls. So you could potentially codify that, something like that in legislation. Another idea is by somebody named Christopher Elmendorf, which is the idea that create a rebuttable presumption on the states in these challenges, where essentially the states at the beginning of the election have to show affirmative proof that they themselves, that their laws were not disparately impacting voters on the basis of race. And I think that's kind of similar and analogous to a previous system under the Voting Rights Act, Section 5, the pre-clearance system, in terms of placing the burden on the states. Regardless, I think there's a wide range of potential options for how this can be implemented. It's more of a theoretical approach. I think it's an important an important approach that Congress should take if it wants to protect voting rights, and I think it should.
How effective of a solution do you think congressional action is likely this current? And I'm mentioning this current Supreme Court, but again, over the last 5+ decades, this current Supreme Court has, and I like it, the term you've taken a pragmatic approach. They've taken a pragmatic approach to pretty much everything related to civil rights, and not just voting rights. And so, how effective of a solution do you think what you're proposing is in the face of this current?
Yeah, no, I think that's a very good point. I think that if we're looking at, potentially middle, more moderate, just whatever the sliding scale the current Supreme Court is, but more moderate ones, I think could potentially be more persuaded by, right, a more textualist argument in terms of the text, something that's specifically embedded right in the text, pointing at very specific things, specific ways, like, you have to interpret it in this specific way, or you have to use this specific mechanism. I don't think it's perfect. I think there's definitely potential situations where another situation like Shelby County, called Section 5 unconstitutional, which can do a pretty good, I would say, normative system. So I don't think it's perfect, but I think if it's crafted with the right intention, it could be something that I think could take.
I had sort of a version of the same question, so maybe it's too much the same, but it was specifically sort of in light of Shelby County and Section 5, and sort of, I think if you had asked, maybe not anybody, most people, even 10 years ago, they would have said the text of the Voting Rights Act does embody the normative view, and it does clearly communicate that. Yet we have verbiage in Shelby County, so I guess, what kind of, I understand sort of the language that you're saying should in there, but to the extent that the current court has found a way to interpret text around those ideas, is there any language that's really going to avoid that?
Yeah, I mean, I don't think there's any fool. There's always another, chance that something could come along and you take an atextualist approach. There's plenty of examples where Supreme Court is using atextualist approach to understand statutes and interpret them in the ways that they want. I think at the very least, what it does it's not a foolproof plan, but it at least gives more, I think, legal support to the dissenting argument, which I think Justice Kagan's dissenting argument is very strong and emphatic from a moral perspective. I think having one more legally sound basis, okay, let's look right at the text. So, I think it's not quite the perfect solution, but I think it's, what we can do.
I think your group begs the same question, right? Which is the Section 5 question over and over again, right? And if there's, I mean, the way that your abstract is set up is that voting rights advocates, right? The voting rights advocates aren't people who legislate. Legislators are people who legislate, right? And if we have legislators who in more recent years more than likely take up only those positions, right? And the majority position, if you have a court that does the same, then what's the practical avenue, I think, to getting where he wants to be?
Right, and that is, the difficult problem. It's not potentially politically possible. Potentially, I wrote this when the Democrats still had control of the House and the Senate, which is definitely a huge knock to the idea. But I think, there's no potentially political will. Maybe we could see shifts and change, but I recognize that it's a very politically contentious this topic, and but looking at the variety of different election legislation that's been attempted to be passed in recent years, I think when looking at that and taking this more theoretical approach, it's I think a possibility in how maybe lobbyists or advocates could discuss it with legislators.
Could you possibly comment on what your thoughts are? What will the executive branch play in terms of the solution?
Yeah. So I didn't think too much about that. I mean, I know that because the executive branch is pretty strongly involved with Section 5. I suppose the executive branch could take more of an effort to bring these types of cases. Frankly, it's not something that I thought too much.
That's all the time we have for questions, but thank you.
Our last presenter will be Hayley Green, that's the National Third Welcome.
So, we made it almost to the end. So thanks everyone for coming out and staying. So I'm going to be talking about traditional medical knowledge, biopiracy, and how to move forward to collaboration. So I'm going to start by introducing the concepts of traditional medical knowledge and biopiracy. Then we're going to go on to talk about science, and we'll finish with the law and how to protect the knowledge. So indigenous traditional medical knowledge is at the heart of biopiracy. This knowledge is how an indigenous community has converted its genetic resources like plants, animals, and minerals into medicines. Biopiracy is the exploitation or theft of this knowledge, especially for use in scientific research, like developing new pharmaceuticals. This knowledge really should be protected to preserve indigenous culture, to strengthen traditional knowledge systems, and to promote further innovation by indigenous communities. So exactly how this knowledge is used in pharmaceutical research is really crucial to a discussion of biopiracy. And because of this, I'm going to be discussing how this traditional knowledge becomes a pharmaceutical treatment as it progresses through 3 disciplines: ethnopharmacology, natural product chemistry, and drug discovery. So while I love science, I know this may not be everyone's cup of tea, but I hope this is at least can be bearable and so ethnopharmacology studies not only how traditional medicines are created, but also looks at correlations between traditional medicines and related pharmaceutical treatments. This knowledge, or this research, helps guide drug discovery by identifying potential compounds for new drugs. It's especially useful for new anti-cancer treatments, which are more likely to be developed from naturally occurring compounds. So these naturally occurring compounds, like those found in traditional medicines, are called natural products, and they're shockingly studied by natural product chemists. So these chemists, first they extract and isolate these compounds from the natural resources. Then they screen all the compounds they isolate, looking to see if any of them have any useful biological activity for treating any condition. The useful ones, they determine its structure. And then at that point, synthetic chemists take over and develop ways to make these natural products with cheap, simple, and plentiful compounds. This research is important for drug development because natural products or natural product derivatives still make up a large share of pharmaceuticals. From 1981 to 2019, they made up 53% of all new drugs and 64% of all new small molecule anti-cancer treatments. So natural products, and actually really any compound, becomes a marketable pharmaceutical through drug discovery. Drug discovery comes in 2 general flavors: classical and structure-based drug design. Classical drug discovery is kind of like finding a needle in a haystack by sifting through the hay piece by piece. Researchers start by synthesizing a bunch of different drug candidates. They then screen those candidates to figure out how good of a drug they are. They then modify the structure, tweaking it to make it better, repeating this process over and over again until the best drug is found. Traditional medicine helps speed up this process by narrowing down the possibility of what a good drug candidate looks like. Basically, you take half the hay out of the haystack. It's easier to find later. In contrast, structure-based drug design is a modern tool to rationally design a drug. It's kind of like you're designing a key for a lock, but in the lock, you know where the tumblers need to be to open it. So researchers first identify a target biomolecule, which is essential to a biological pathway triggered by the condition you want to treat. They then, a drug candidate is then assembled based on how it would interact with that biomolecule receptor. Candidates are then optimized based on how well they bind and interact with that biomolecule, and optimize and tweak until the best one is found. In this process, traditional medical knowledge is useful for identifying target bioreceptors,
as well as understanding how known traditional treatments will interact with the receptor. So the whole point of this scientific rabbit hole, there's a point, is to deal with arguments that protecting traditional medical knowledge will unreasonably impede scientific research. These concerns are really misplaced for two reasons. First, intellectual property licensing is incredibly common, especially in the pharmaceutical industry. Temple law even has a whole class on it. And second, because, as we discussed, this knowledge is really used as a starting point in this research, scientists can easily contract with indigenous communities to get access to the knowledge without unreasonably burdening the progress of science. So now, you made it through the science, we're gonna talk about the law. So positive protection is basically an intellectual property right in the traditional knowledge, and is theoretically possible under existing trade secret and patent laws. However, it's practically impossible for indigenous communities to protect their knowledge this way. The biggest obstacle is the past prior public disclosures of a lot of this knowledge. For trade secrets, this means that indigenous communities are not going to be able to meet the secrecy requirement, protecting their knowledge as a trade secret. Similarly, for patents, these prior disclosures are included in something that's called prior art, which is a body of references that an invention is compared to determine its patentability. So this creates a catch-22 where the traditional medical knowledge is never going to be patentable over this prior art because of these prior disclosures. So overall, the problem with positive protection is that the damage has already been done. The knowledge has been disclosed and cannot be protected. Without a major overhaul of existing IP laws, which is really unlikely, indigenous communities are going to be left out. But defensive protection can help. So defensive protection offers practical solutions to protect the interests of indigenous communities. Documentation allows communities to collect, use, and disseminate their knowledge. The communities can preserve and protect their knowledge by compiling it into databases. These databases can be used as prior art to prevent third parties from obtaining IP rights in the knowledge. But unfortunately, documentation alone is really only a band-aid. In contrast, patent disclosure requirements impose a duty on patent applicants to disclose traditional medical knowledge used in their invention. Countries can use these disclosures to monitor how this knowledge is being used, as well as ensure that these communities are not being exploited. However, without a binding international obligation to oppose these disclosures, countries have implemented their own laws, creating an inconsistent patchwork of disclosure. So finally, access and benefit sharing agreements allow that, ensure that indigenous communities can benefit from uses of their knowledge, but also it allows scientific research to continue. These agreements ensure that researchers get prior informed consent from communities before using the knowledge for genetic resources. In exchange for this use, the researchers must compensate the communities. This compensation will generally be monetary, but could really be anything just to receive. The bottom line with defensive protection is that all these measures used collectively can be enough to give the indigenous communities a de facto right in their knowledge in the absence of an actual IP right in knowledge under existing laws. So what I really hope you get from this is that traditional medical knowledge has been used in scientific research and especially in pharmaceutical development. But this knowledge, protecting this knowledge would not unreasonably impede research. Positive protection is really inadequate and unlikely to ever protect traditional medical knowledge. But defensive protection offers practical solutions to allow indigenous communities control over their knowledge. Thanks for listening.
So this might seem really basic, but one of the things sort of I kept thinking and wondering in looking at your paper and your presentation, and so I guess you sort of hint at it, you talk about defensive protection, but what do you mean by protect? I mean, say protecting, like, is it, I mean, I know it's more than a thing and it's complex, but sort of are you thinking mostly in terms of not allowing other people to profit from it? Is it attribution? Is it maintaining the knowledge?
Yeah.
What protection mean?
Yeah, I mean, I think it can mean a lot of different things. Also, depending on what a community wants it to mean, because I mean, they're definitely not homogenous. They all may have different interests. I mean, at this point, pragmatically and realistically, I'd say protection means stopping exploitation of this knowledge. And I don't know if under the current climate, it will ever be more than that. I think an ideal world protection means these communities can have an intellectual property right in the knowledge. But I think at bare minimum, it's allowing them to stop theft of this knowledge.
I guess I also have a definition question. Who are indigenous communities?
So for the communities that like the American Indian, many small community in a country that was there first before colonizers came, they're the ones that had this deep relationship with the land that and this knowledge comes out of that relationship, how they learn to live with it, use it.
Yeah, I guess I mean more pragmatically, right? Because if one of your interventions are the access and benefit sharing agreement, I'm say for instance, Johns Hopkins, the institution very interested in giving that agreement. And I want to use some indigenous knowledge from a Native American population around something. Who am I going to? Am I going to the Sioux? Am I going to the Muskogee? Am I going to Oklahoma? Am I going to who is the person? Because somebody has to find the agreement, right? Yeah. So who is the person? Who am I going to? Assuming that a lot of different indigenous communities might have very similar traditional medical knowledge or traditional medical products.
Yeah, I mean it is complex, and I think that's one of the problems with why the issue has been and kept going this long. I remember in I have the exact details, but for access to benefit sharing agreements specifically, Peru has a really good framework where the communities, they have to appoint like they call it basically a bargainer on their behalf who deals with the scientists or the company that wants to come in. And that negotiator bargainer has to talk to the community and disseminate what is being offered, what's the issue. But you kind of already know who you're going to then. So I guess my answer to your question is, I think as scientists, when they know there's a traditional medicine and they kind of know where that's coming from. So there's an example of the hoodie cactus in South Africa, and the CSIR, I forget what it stands for, but it's a research institute that knew about this cactus and knew that some people used it as food on long hunts. And then they patented the natural product in it as a weight loss drug and licensed it to Pfizer. So like CSIR, they knew who owned it. I think, don't know if I have a solution. If you don't know where the knowledge came from, but I don't know, I think you would have to, if you know a bush or a shrub or something has become a medicine, yeah, I think you have some idea of where it is. I mean, you can always just put the burden on the company. Like if you want to use this and you have reason to believe it's an indigenous community's property, you need to figure it out and you need to do it. Because I think they would have the resources. That's kind of a long-winded answer to your question.
It was very, very helpful. I think that you're going to have to deal with the problem of competing.
Yeah.
Right. And how you would and how you restructure your framework would address competing.
Yeah. And I mean, patents, I'm more familiar with patents, and that is also still a really regional system. So like, it can also be divided up by country. So like, you want to patent something in the US, you have to figure out who would have a claim over to the US. Same with, and you want to patent in Canada, you have to figure out. So it could vary in different communities in different countries. You just go to that community in the country. I mean, there are quite a lot of ways you could do it, and it is complex.
I see two options. Yes. One that both of them I see. First is the federal government relationship directive. That's it. And second, the power of the pharmaceutical industry in Washington, D.C. And I definitely don't see them going along with any proposal.
Yeah.
So I would like you to speak to some of the solution, like how do we overcome both that record and the power that the industry has.
And the US is very much not, there's been a few conventions on the international level that have been non-binding. The US hasn't signed on to any of them. So they're really not about this. But the pharma industry, when there's been examples like Kodiak cactus, when they've been caught and public outcry has been enough to convince them to enter in agreements to share benefits. But the one thing about patents is that even though the US is a big market for any global industry, you need to get a US patent. There's also others like European patents to it, that the costs of prosecuting all those patents, it's easier just to, like if you're already signing an agreement with Europe, you need it to get a European patent, you're gonna do it anyway. It doesn't really matter if you need it with the US. So honestly, I don't see the US doing anything. I mean, they're probably not. But I think European nations, there are enough that if they impose new requirements, the pharma industry may just have to do it anyway to be able to want to practice their patents in those countries.